Hi, I'm John Strohmeyer, and you're back at the Strohmeyer Law PLLC YouTube channel. Today we're going to be talking about the first two questions we need to ask whenever we're dealing with probate. Whenever we deal with probate, we have two things that we need to talk about before we can figure out what the plan is going to be for administering the estate. First, what's the document that's going to control the disposition of assets? And second, how much administration do we need for this estate? Those two questions, the way we answer those two questions will determine what process and what procedures we're going to look for, as well as other things that may need to ensure that we can do a smooth and orderly administration of an estate. So question number one, what controls? Most of the time, we're looking for a last will. The problem is if we don't have a last will, which is a document that's created during lifetime to control the disposition of assets on death, well, then we're looking at an heirship. Now, here in Texas, a probate administration with a last will is generally pretty easy and straightforward, requiring only one trip to the courthouse. An administration with an heirship, meaning that we don't have a last will and we have what is known as an intestacy, requires multiple attorneys to get involved before we can get things done. So, our preference is always going to be for a last will and testament or something that looks like a last will and testament. If we don't have that, we'll have to go through what is known as an heirship to determine who is entitled to property. Our second question is, how much administration do we need for this estate? Sometimes we may not need much. Sometimes we may need the whole estate to be administered, and we're going to have to run through all the steps to make sure that we take care of the assets in the estate. And sometimes we'll need somewhere in the middle. So a lot of this depends on who has passed and what did they own, as well as who is receiving it and how do they need to get it. One of the things, so on the easier end, an order of no administration might say, well, there's a last will and we don't need to do anything for it. And on the other end, we may need to do the full administration because we have to settle tax debts, we have to transfer real property, and we may need to sell certain assets owned by the estate. Somewhere in the middle, we may need to just transfer title to assets from the decedent's name into one of the beneficiaries. If we're in that case, we may be looking at something known as a muniment of title here in Texas. Now, this is just an introduction. I've got over 16 different procedures in Texas that I use to classify what we're going to do for an estate, and we're not going to get to all of those today. We'll be using the next series of videos to go through each of those options and when they're appropriate and when they're not. Thanks.